Okay, ladies and gentlemen, please take your seats. This is a very special presentation, and it may be, Scott can correct me on this, but our next speaker is probably the most junior and youngest person that's ever spoken at this conference. And and the reason she's speaking here is she went to Duke for undergrad, so that's good enough for me. Even though she went to Harvard for law school, we'll try not to overlook that. And she majored in mathematics when she was at Duke. But one of the most interesting things, Lindsay has been involved in this sexual assault issue that's been plaguing the armed forces, but in maybe a little bit different way than what you've heard in the media, and that's one reason why I asked her to come down here. Lindsay, being a math major, wrote an op-ed that was published in the Wall Street Journal shortly after the survey was released that estimated that there were some 26,000 sexual assaults in the armed forces. Note the word estimated. And I'll let her explain this more, but let's just say the title of her op-ed was "The Pentagon's Bad Math." And when you have a math major looking at how a survey was conducted and so forth, it was pretty devastating. But I think even more important was her article that she wrote in Joint Force Quarterly, talking about the dialogue that's necessary to really solve the sexual assault issue in the armed forces. And she has some very different ideas, and she's a very articulate young woman, and here she is. Without further ado.
Thank you very much. Throughout the morning, I've been meeting folks, which is a great pleasure, and we've had talks on Guantanamo and drones and big data and Edward Snowden, and I've had more than one person comment on how I had the really controversial topic. So that's a dubious distinction, but here we go. First, I would like to reiterate the disclaimer that General Dunlap made at the beginning. I think it's particularly important because you do see me here in uniform. I'm really speaking for myself. I am not speaking for the chairman, for DOD, for the Marine Corps. Occasionally, I will reference the stances that the military has taken on things. Hopefully, I'm clearly distinguishing between my opinion and the stance that the military has taken. If I'm not, please help me clarify, ask the question. I'm happy to answer it. I also want to thank General Dunlap for, I guess, taking the risk that he exposed to you guys. Here I am, I suppose, youngest and least distinguished speaker you've ever had. So I'm going to give this my best shot, but you don't have that prize. But I really do appreciate you bringing me down here. It's a great honor to be on this list of incredible speakers. It is a great thrill to be invited back to Duke for all the basketball jabs we've had. I was a line monitor, if you guys know what that means, so you know that I'm big on Duke basketball, big fan, and ecstatic to be back in Durham. Moving to this topic, I am really dedicated to having a dispassionate conversation about sexual assault in the military. Too often, I think that this issue sparks so much emotion that we cannot speak rationally and effectively and constructively about what we should be doing about this issue. And I don't think that that criticism is fairly lobbied against one side and not the other. I think it's fairly lobbied against both sides. I think you get a lot of emotion on one side, and frankly, I think you get a lot of clamming up on the other side. So here I am, speaking for myself, but in uniform, I'm not clammed up. That's probably why you got me. So in my spare time, one of the things that I do is I volunteer at the DC Rape Crisis Center. And one of the things that we do at the beginning of every sort of volunteer training meeting is put our expectations up on the board. And these are all people who are extremely dedicated to this cause, and it is a very friendly environment. And still, it is very important to clarify that there should not be any judgment as we're trying to talk constructively and dispassionately about how we can better serve victims. You should assume the best intentions when someone's talking about this issue, trying to be constructive. ask to clarify before you judge based on what someone will say. So I say that because I hope that you will receive my comments with that framework in mind, and I hope to only speak for about 20 minutes and then leave the rest of my time for your questions, because the real goal that I have is to have a constructive dialogue about this. So the elephant in the room, I'm not really going to, as a Marine bottom line up front, is of course the proposal to take commanders out of the disposition decision and prosecution. That is Senator Gilbrans' proposal. That's what's in the media. That's what's in the newspapers. I will touch on that. It is going to come later in my remarks. But I'll just lay it out there right up front. This is who you're getting. I do not think that that is good policy. I don't think that that helps our victims, and I don't think that it moves the ball forward in addressing sexual assault in the military. Some people would say that it's noise, that it's a distraction. I'm not sure that that's fair criticism, because I don't think that I would be standing here at this incredibly distinguished conference if this issue weren't in the paper every day and at the forefront, and that is the boot on the neck of the military. That is what has gotten us to this point and why we are talking about it at this level at this point. So it would be disingenuous to say that it has not done any good, even as the threat that it is. I think the military perceives it to be, though, the nuclear option. So right now, all the scrambling that you see from the military doing all this hard work to be much better on sexual assault is driven in part by the idea of the nuclear option hanging over their heads. So that's sort of my perspective, and I'll get specifically to that policy later, but I figured you should know who's speaking to you. And let me sort of address what's in the media, because I think that that's probably where the vast majority of you are coming from. The latest media information that we've gotten is this AP report about cases in Japan, and I was stationed in Japan for a couple of years, cases in Japan that were sexual assault related from 2005 until 2013, and they then picked a couple of them that they thought were mishandled in some capacity that didn't go forward, and that was supposed to be sort of like a big impetus to support certain policy agendas. Well, the difficulty I have with that is really the time frame. And when we're talking about sexual assault in the military, I think the frame that you have to come to this question is that fixing sexual assault in the military is like shooting on a moving target, because every year we have so much change in the landscape having to do with the policies and the laws that we're implementing. So the 2005 landscape has nothing to do with what we have today. 2005 is when we implemented the use of restricted and unrestricted reports, which now are just sort of very commonplace, restricted being a report where you avail yourself of all the services that you get as a victim, but that you don't instigate an investigation, and then unrestricted being that you would like this investigated criminally as well. The victim advocate community has been completely professionalized since then. The law, the actual rape statute that we have, has been revised twice since then. And so we really, when you talk about what happened in 2005, 2006, even 2008, 9, 10, you're just not talking about today's policies. And so if you criticize what was happening in the military in 2008, 2009, what you're doing is highlighting the importance of the policies that we've implemented and highlighting a history that we don't want to revert to. But what you're not informing is what the policy solutions that we should be exploring today are and what the best way forward should be. So I have real difficulty when I read the paper because I feel like those issues are very conflated. The historical importance, and it's weird to talk about 2005 as history, but based on how much change we've seen in the military on this question in the past really just 2 years, but you can go back probably 4 or 5 years and just see every year the NDAA is riddled with legislative changes. We had 60 just in the past 2 years. So 60 different provisions in the NDAA changing the landscape on sexual assault, and that has nothing to do with the policies that have been changed internally to DOD that didn't require legislative fix. So it's hard speaking to an audience who I know is mostly informed by what's in the media because we don't have a lot that's there. So as we talk about the problem of sexual assault in the military and then the best proposed solutions for addressing that problem, I'd like to raise a couple of lenses, ways that we should be thinking about the problem. And the reason that that's so important is because my sort of big slogan is that solutions should be paired with problems, right? We should be pairing proposed policy solutions with an identified problem, and that solution should be adequately paired with the problem that it solves to where there's a direct link. And so this problem of sexual assault in the military is really broad and ill-defined. And depending on who you ask, one could define it in different ways. So I'll give you my perspective on that, and then, of course, during the question period, I'd love to hear any other perspectives. The narrowest definition, and the one that actually you hear in the media a lot, is that the problem of sexual assault in the military is a problem of too many men raping women in the military, right? That there are tons of rapes happening in the military. Another way to articulate the problem is that we live in a very male-dominated military. The Marine Corps is 94% male. I've been told I'm a unicorn because I'm a female Marine officer, since it's rare that you ever see one. So the issue in the military having to do with sexual assault is really an issue of greater generalized sexism in the military. You have so much male dominance in the military that this fosters a culture where women are not respected and appreciated, and the sexual assaults will precipitate from that culture. So those are two proposed policy definitions of the problem. What is the answer? Probably both and neither, somewhere in between. But depending on how you look at it and which lens you focus on it with, you could obviously prescribe very different policy solutions. Another way that we sort of often just have difficulty in defining the problem is when we focus on victims versus offenders. So the academic right answer when it comes to sexual assault is always sexual assault is about power and control, right? So if you ask anyone who studies gender-based violence, anyone who studies these issues in the VAWA context, the Violence Against Women Act context, it's always sexual assault is about power and control, always. So DC Rape Crisis Center, when I do my work there and they say, what is sexual assault? I say power and control, right? I mean, that's the right answer. But that is a very victim-focused perspective, right? It is about loss of power and control for the victim. And that is really true when you look at sexual trauma and you take a step back, sort of regardless of who experiences it and how they experience it. If you've experienced sexual trauma, you've experienced a loss of power and control, and a lot about the healing process is about regaining power and control. However, and that's really important for providing victim services, but when we're talking about prevention, studying the effect that sexual assault has on the victim doesn't actually get us to where we need to be in terms of preventing perpetrators from these sorts of criminal activities. And I don't love the lens of power and control when it comes to the offender. This is controversial. This is not really accepted in academia. This is just Lindsay. Because I don't see in the cases that we get the power and control model in every case. I see power and control in a lot of the cases that you'll see that have to do with trainers and trainees, that have to do with abuse of rank, and those cases do exist, and I think that they're fairly within that power and control model. The stranger in the bushes model, which is, of course, the sort of rape myth that so much of activism in this area has been trying to overcome, but of course that crime still exists in our society. It's rare, but it exists. The stranger in the bushes model is also a really psychopathic crime. I don't know that it's about power control so much as it's just about violence. And so that's sort of another category altogether. The problem of sexual assault in the military, I don't think is fairly categorized by extrapolating too much from that paradigm, but of course we have to be able to encompass those cases in whatever policies we put forward. And then finally, I've struggled with what to call this. I'm going to call it the opportunistic model or the amoral model, but I think a lot of our cases fall into this category of a prototypically drunk 18 to 24-year-old who is not trying to take power and control away from someone, but who is placing their own sexual gratification amorally above the potential trauma that they're inflicting on someone in a momentary lapse of judgment. That's controversial. A lot of people won't agree with me, but that's really what I think I see when I see a lot of these cases. The reason I say that, and I was a defense counsel in Okinawa, so I've been on both sides. I've been prosecutor, I've been defense. And I think that that's actually a really eye-opening experience for someone who's sort of worked on the other side of these issues a lot, because you have to learn to empathize with the offender in order to really understand what the problem is and where it might derive from. And in my anecdotal experience, that is a really important model that we haven't really been able to appreciate. So I'll take tons of questions on that later if you have them. And then the last sort of lens that we have in terms of problem definition, other than sort of anecdotes, and of course, the plural of anecdote is not data, right, is the surveys. And we really only have two. General Dunlap has given you a preview of my opinion about one of them. One of them is this 26,000 number. And he alluded to this, and I'm happy to take more thorough questions about this if you have them. It's just not well extrapolated. So I've talked to many statisticians and economists on this because I was a mathematician in college, and there actually is a distinction between statisticians, economists, and mathematicians, and I was pure, nerdy, chalk on a chalkboard type mathematician, no practical application whatsoever, which is why I had to go to law school. But that study is, when you dig deeper into the data, we can learn actually a lot more even from those survey responses, and you start whittling down the number, and it is, first of all, likely lower, and second of all, it's much more nuanced than that number would imply, because that number says 26,000 rapes in the military. Well, okay. That's not even what the survey was asking. It was actually asking about contact, and they had a small sample size, and that number is an extrapolation. So if we'd surveyed everyone in the military because 1% of survey respondents said X, then how many military-wide would have said X, right? You can't do that because of the way that the survey was structured. And it's also not useful because you get these sort of weird, so you had about 6% of women and about 1% of men saying that they had been, 4% of women and 1% of men saying that they had experienced some form of unwanted sexual contact or attempted unwanted sexual contact. Well, the extrapolation is based on about 12,000 women and about 14,000 men. That's where you get 26,000. So then you have to ask lots of follow-up questions about, like, who are these men? Because we're not prosecuting these cases. I have prosecuted male-on-male sexual assaults and defended both sides. They're just fewer and farther between. They exist, but they're few and farther between. Fair criticism on the other side. Well, they're just not reporting because there's much more shame involved with being a male victim than with being a female victim. And that's fair, but we really don't have evidence of that. So this is really a survey in a vacuum. And when you look into those surveys, you see that most of the female complaints were about penetration crimes. So they're really what we're talking about is sexual assault. And a lot of them are what we call incapacitation crimes. So like I was passed out at a party and he took advantage of me. Or I blacked out and I don't know what happened, but I'm pretty sure he had sex with me. The male equivalent, the sort of about 80 to 85% of the male responses were about, and I'm sorry, this is a little colorful, but were about what we would call locker room ball grabbing incidents, right? So they were like, oh, well, some guy grabbed my junk in the locker room a couple weeks ago, like, and they actually wrote in the survey, like, this is what happened to me. Now, if that male is experiencing sexual trauma based on that interaction, if that was threatening to him, or somehow if he's, wants to seek services having to do with that, if he wants to prosecute that because it is super inappropriate, that's important. But I think many men are not actually traumatized and would not categorize it in that way, right? It's very context dependent whether that qualifies as something that we're going to prosecute, and it's really just based on the trauma experienced by that person. And it's just a very different story than what you're hearing in the media about what that number means. So there's that. The other survey is the CDC survey that came out in March of 2013, so about a year ago. And it was a age and marital status controlled survey of military women, military spouses, and civilian women, and it found that the rate of sexual assault in the military is exactly the same as the rate in the civilian world. So those are the two surveys that we have. Many of you have probably not heard of the CDC survey because it doesn't tell the media narrative that has become very popular, but it's there, it's available, I can show it to you. Those are the two surveys that we have. So now where do we go? We have data that we don't really know what to do with. And I'm going to use the remainder of the time I've allotted myself to talk about proposed policy solutions. There's been a lot that has changed in the military thus far, and I've sort of touched on that. The things like this proposal to take commanders' decision out of the prosecutorial decision-making process have really instigated a lot of change. I think another sort of controversial source of pressure was The Invisible War, right? A lot of folks in the military hate that movie because it's riddled with some inaccuracies, but it has also spurred some really constructive change. So, good on them to some extent. At the same time, some of the changes that are being proposed or that have gone into effect aren't all constructive. So sometimes this sort of reactive policymaking doesn't land us where we want to be, which is why, like I said, I'm really hoping to sort of lay it all out there and have more of a constructive conversation. So I'm going to highlight a couple of the policies that I think are relevant that might be interesting to talk about. I'm not going to dwell too much on many of them because I do want to be responsive to your questions. So things like Article 32 and Article 60, I'm not going to dwell on them. Those are the pre-trial and post-trial processes having to do with sexual assault prosecution. I'm happy to touch on them, but they're basically done. They've been legislative. Those changes have been made. The military is happy with them. Congress is happy with them. They're really not controversial at this point. What I am going to touch on briefly are the use of victim advocates, the use of victims' counsel, the role of the commander. Like I said, I was going to get to that. And then the question about training. So what do we do in terms of training? So victim advocates. There are two different models for victim advocates. DoD uses one, and I would call this the untainted model. Our victim advocates are civilian, they are professionalized, they're outside of the chain of command, and they are meant to be outside of all other processes having to do with sexual assault prosecution, investigation, and that sort of thing. And that is very useful for lots of reasons, mostly because they are untainted, right? The victim will never question the perspective or the conflict of interests associated with that victim advocate. The model that most DA's offices have actually embraced is a more incorporated victim advocate model. And the incorporated victim advocate model is that they have social workers who are working in the prosecution shops whose job it is to really serve as a resource for victims. Now, these are not mutually exclusive. There's no reason that you couldn't have an outside victim advocate and an inside victim advocate. But DoD has actually opted against this model. And the reason why is because there is so much criticism about DoD about remaining untainted and ensuring that victims never question the conflicts that their victim advocate might face. The potential detriment with that model is that we hear a lot in terms of, anecdotally, but from victims, in terms of part of the trauma associated with the justice process has to do with the opacity of the system and the complexity of the system. So if you are an E3, a Lance Corporal, going through this process, you don't know everything about the military justice process. And we've heard a lot that what happens is that victims will say, this system is so confusing, I don't understand what's going on. And I've been there and heard victim advocates say, you're right, it is so confusing. I can see why that would be really stressful for you. I would like to see us move to a system where the victim advocate can confidently say, what's confusing you about it? I can educate you because I'm well-informed, because I know what's going on. And we've actually sort of decided not to go in that direction. We, big DOD, not Lindsay. So I have some mixed feelings about that. Victims' Counsel. Victims' Counsel does not get enough credit for how revolutionary this change is. We in the military have introduced third-party litigation into all of our sexual assault criminal litigation at this point. We don't know the extent of it, and we're going to make our appellate courts figure that out. So right now, every victim who, it just is what it is. Right now, the policy is that every victim gets a victim advocate. It's a judge advocate who is completely non-conflicted. There's a separate defense counsel chain, prosecution chain, and a separate victim advocate chain in every service now. And And to be perfectly frank, the Marine Corps and the Army opposed this policy initially because we were very concerned constitutionally about what it means to have third-party litigation in criminal matters. And like I said, the appellate courts are going to have to figure it out because the reason we went with this policy was because the number one criticism from Congress has been, and this has evolved over time, but right now they've landed on victims aren't reporting enough. Victims aren't comfortable coming forward with these crimes. And we could not find a better solution than you're going to get your own lawyer the second you come forward, and you will be protected through that lawyer. And it has been very effective. There's no question that victims feel protected. The Air Force in particular has had lots of surveys about this, and the program is a resounding success from that perspective. From the constitutional criminal law perspective, it remains to be seen. So, role of the commander. I'm trying to wrap up quickly, so I'm just checking these off my list. The problem, like I said, from Congress has been defined right now that victims are not comfortable coming forward. At this point, I think that we've changed enough of the landscape having to do with prosecution and investigation, and if it isn't changed yet, the policies are in place, and so you just sort of have to wait for them to take effect in terms of, hiring new people, training new people. And everyone seems to be satisfied that we are doing well on that front. So the real issue is victims may still not have faith in the process. That is countered by the most recent data that we have about victim reporting, which is that it's up 50% from last year, which was the highest that we'd ever had before that. So there is a huge increase in victim reporting. The problem is our prevalence data, the data about what is the total number of sexual assaults that you're trying to get reported isn't good. So we don't know what our target is. And the biggest problem with the lack of prevalence data is we don't know how to show improvement either, right? So the next time we get a survey, it might say 10,000, it might say 50,000, it won't mean anything because we don't really have accurate sense of what the baseline is. The problem with taking the commander out of the decision-making role to prosecute as a response to victim reporting is that the link between the two of them is so tenuous, right? There's the question of what's getting prosecuted has sort of been addressed. We've got numbers that say that the military prosecutes more of these cases as a percentage of the whole than the civilian world. So there's no issue with commanders not being willing to come forward, and that's basically been conceded on the Hill at this point. So the issue is really just a symbolic measure, right? It would symbolize to victims to take this power away from commanders that now it's safe for them to come forward. I have sort of fundamental problems with symbolic reform, right? I mean, if substantively this policy is not going to make the process better, then I think we can find better ways to do it. And one thing that I think is not symbolic at all and hugely impactful is this idea that every victim gets a lawyer now. Another thing that gets conflated in the media is this issue of victims having to report to their rapist, right? This gets reported in the media a lot. Those cases are very few and far between. There's no question that if someone were to report outside their chain of command, that they would not then have to serve within that chain of command. They can get moved immediately. The commander's under investigation. Obviously, he or she's going to get suspended pretty quickly from being in that role. There's also no way to bury an investigation anymore. And so there were ways to bury investigations in 1991, definitely probably still in 2005. There's just no way to do that anymore because those policies have fixed that. So you report now, it immediately goes to the MCIO, the Military Criminal Investigative Organization, and they do an independent investigation, and that's done by civilians, and that's true in every sexual assault case. So there's no way to take for a commander to crush it, basically, before it all comes out in the open. So really, all you're talking about is once you've had a full investigation, whether a commander or a judge advocate should say that the case goes forward to trial. And all the judge advocates in the room will probably agree with this, and if you don't, let me know. The judge advocates are actually going to be more reluctant to send those cases forward than commanders, and we have a lot of data about this. I see lots of shaking heads up there. Thank you for your support. And the reason why is because we make decisions based on likelihood of success at trial, and the commander's making decisions about what's best for the unit and what's best for command climate reasons. And command climate reasons, the right answer is usually crush it, send it to court, send that message. from the winning, likelihood of success at trial, these cases are really hard to prosecute, which isn't to say that we shouldn't try, which isn't to say that people shouldn't have their day in court, but you end up with acquittals in some cases where you think it's more likely than not that that person was guilty, but you might not have gotten to reasonable doubt. And there's just a lot of cases in that gray area. So I'm sorry. So I was touching on this issue of like chain of command, and another issue that gets conflated in the media is this question of who the commander is versus who the convening authority is. So this policy is aimed strictly at the 06 colonel or Navy or Coast Guard captain who is making the decision about whether to prosecute. So when we hear victim stories in the media, and like I said, I think they're really important. I think they explain the history of sort of why it's important to do well on this topic and do well for victims in the future. You'll hear them say, oh, well, he was in my chain of command, or he was a part of my unit, or something like that. That's all something that we need to address honestly, through culture change, through ensuring that Marines are taking care of Marines, soldiers are taking care of soldiers, that no one in your unit or your supervisor should think that anything like that's appropriate. But that has nothing to do with the colonel making a decision about prosecution. They're fundamentally different, because the convening authority, the commander making that decision, is a much higher level commander than who you might think your commander is, if that's the sergeant or even the lieutenant who's a platoon commander. That's still many levels of hierarchy away from where this decision is being made. So one last thing that I'm going to say on training, and then I'll open it up to questions, is training has been a major punching bag. Senator McCaskill said, you can't train your way out of this problem. I think she's been a hero on this issue. I know that she's very well educated on this issue. I actually disagree with her, and the reason that I do is because so much of this is a question, like I was getting at a little earlier, about the culture and about mutual respect. And the short-term fixes are these policy changes. The long-term fixes is, and this sounds a little Pollyannish, but is creating a society in which people don't ever contemplate doing this to each other. And you can only do that through what the military calls training. And you may not think of it as training in the rest of your lives, but in the military, that when we talk about sort of forming identities as Marines and soldiers and airmen and sailors and coasties, that's what we're talking about, is we're talking about training. So I think training is very important, and the criticism that we get about training is never constructive. They will take the training apart, and that is because talking about sexual assault is really awkward. Talking about penises and vaginas with 18 to 24-year-olds who really don't want to be sitting there getting that training is really, really difficult. I have never heard someone criticize the training and saying, you should look to so-and-so's training, it's really good. And so if there's a source of great training out there, please show it to me. Please show it to every academic dean at every college in the country. And please show it to every high school. I mean, I think the world is lacking in what good training is on this question. And if we can find it, I think that would be great. I'm going to end there because I talked longer than I planned to, and I look forward to your questions.
Lindsay, that was really terrific, and you've raised a bunch of issues. I'm going to take the prerogative of being the general and ask the first question. One of the interesting things, and you alluded to the CDC survey that shows that the sexual assault rate in the civilian world is very similar to that in the military, and there are other studies, as you know, that show that military is actually lower than the civilian. I'm not sure if you're the mathematician, whether there's a statistical difference. That would seem to rebut the notion that it's the male culture in the military that is causing sexual assault. What do you think explains the equivalency? And related to that, my anecdotal experience is that a lot of these cases arise because we have very young troops who they're smart people, but they don't have much social skills, and they don't necessarily know how to relate to the other gender unless they're drunk and they're drunk. Would that be part of the training fix that you would talk about?
Yeah, so I'll take the last one first. Yes, I think that we have this problem. I don't think that it's a coincidence that President Obama gave a sort of ultimatum to the military saying, fix it, I want a progress report from you in a year, and then not within 2 weeks issued basically a similar ultimatum to colleges and universities and ordered this nationwide study on this issue in colleges and universities. I think we're really dealing demographically with a very similar population, and we get them from the same place, right? I mean, people see a fork in the road and they go, not college, not military, military, not college, or military, right? I mean, those are the, or college, right? Those are the options. So, yes, I do think that's an issue. So in terms of the equivalency, first, I think that, so part of my sort of bandwagon of dispassionate conversation about this issue is when you say the numbers are the same as civilian society, it immediately gets heard as this is not a problem. I think it's a problem in civilian society, so that doesn't tell me anything. Second of all, I'm sure that there are a lot of context-dependent aspects of military service that make this type of trauma unique within the military context, and the way that it's experienced and processed, therefore, needs to be more carefully thought out than in the civilian world because of sort of the special responsibility we have to our service members, and then both on the victim side and our special responsibility we have to sort of hold accountable the service members who are perpetrating. So I think it's a little bit of red herring. I don't think it matters. And I just don't think we have enough data to be able to say one way or the other. And I think right now the thing that we do know is that it is maybe comparable. The last thing I will say, the sexism issue I don't think is a red herring. And the reason, the sort of male-dominated culture thing. And the reason I don't, and this is anecdotal as well, and I criticize people for being anecdotal, and then I reserve the right to be anecdotal myself. When I talk to other female officers about this question, very often I hear a lot of frustration because the concentration on this issue of the commander's role in disposition decisions and prosecutions is so narrow. When many female officers experience in the military hasn't necessarily risen to sexual assault, but there is a spectrum of bad behavior all the way from sort of disrespect to sexual assault, and they may be somewhere else on that spectrum. And so they don't feel like their experiences have been honored in this conversation because that is a really important aspect of the male-dominated culture, and it's one that we're not talking about because we're so focused on this question about whether commanders are going to make disposition decisions and prosecutions of penetration crimes. So I don't know the answer to your question, sir, but...
Trust me, your answer is better than the one that I had up here. Let's open it up to questions from the Professor Curtis.
As you can imagine, this is a hot issue at the academies, and especially at the Naval Academy where I am. And I find, for one, sometimes I think we engage in overkill, given the knowledge, the youthness of especially the midshipmen. And there's a tendency to, okay, let's identify a problem, let's, make them go to meetings, and it's a constant thing like that. What I found to be quite disturbing to me that in the media, there was always this example of the JAG officers, the courts, essentially finding an individual guilty, and then the commander, whether he's a wing commander or the superintendent. Well, no, I shouldn't use that because I work for the suit. But they reverse it. Mm-hmm. And civilians have a negative reaction to that. And I think that's behind this issue of taking the military commander out of the loop. I think it's a bad idea because, frankly, I want to ask you, what are the potential negative effects of taking the command out of the loop? Because what does that do to the perception of the chain of command, the legal status, and so forth?
So your original point about this issue that's been in the media about whether commanders, after the guilty finding in a court-martial, can reverse a decision that has been undone through legislation. So when I said I wasn't going to touch on the pre or post-trial fixes in the legislation, that was basically fixed. And the fixes has made Congress happy and has made the military happy. The way that we do plea agreements is very much affected by how it's tweaked. So it's kind of complicated to get into, and I can get into it more with folks offline if they want to. But that has basically been resolved at this point. They took away the commander's ability to do that in the cases where we care that they don't have the ability to do that. So that's been satisfied. So the question is, at the beginning of the case, whether the decision to move forward with a court-martial should lie with the commander. And my concern is that we talk past each other when we talk about this. The sort of victim advocacy lobby will say, victims want this. And the military will say, commanders require this authority for the benefit of good order and discipline. And it's like, okay, nobody's talking to the concerns of the other party. And I fear that some of the military rhetoric sort of sounds like the benevolent dictator model, right? It's like the commander must retain all authorities for the benefit of the victim, and that doesn't resonate very well. But I actually don't think it's good policy because I really don't see how it serves the interest of victims. And I think if you take a very victim-centric approach, and I think we should be looking through this lens more than maybe we currently do, what is it that victims are concerned about? They're concerned that if they are going forward with a case, that the commander will take the allegation seriously and take it to court if the investigation provides enough evidence to warrant a court-martial. And we know that commanders are more likely to do so than prosecutors. So there's sort of like a fundamental fallacy in the way that the policy is constructed from that front. I'm also concerned because victims say that they want a voice in the process, and that's really, they want their day in court and they want to be heard. Keep in mind that when you talk to victims anecdotally, they never say, like, I wanted a conviction. I mean, they know that they want a conviction, but that's not really the source of their dissatisfaction with the process. Their source of dissatisfaction is lack of inclusion, and I don't see how a bureaucratic prosecutor is going to be more receptive to victim input in the decision-making process than the commander. I think those of us in uniform, it's sort of easier for us to appreciate this, but and I'm really looking forward to Phil talking about the civil-military divide because I think we need to do more on that front too. But you know, the victim will have much better access to a commander than probably an off-base prosecutor. I mean, the way that this legislation is formulated, the idea that a victim would be more heard by a prosecutor who's somewhere else who's deciding whether to go forward with a prosecution than a commander who's taking a holistic view of the allegation and how best to dispose of the case and provide resources to the victim. I just don't see it. I see the victim being better taken care of in the current model than in that future model.
Let's have one of our Elon students.
Hi, I'm Julie Dowan from Elon University in Greensboro. I actually had a question. You were talking about how you don't think that it's about power and control, and you said that that's a little bit controversial. Could you explain that a little bit?
Sure. Well, so...
And how you arrived at that, I guess.
Yeah, you don't see... I've seen very few criminological or sort of psychology of the offender studies. Most of the work in this area comes from the gender-based violence sociology type perspective. And when you're very victim-focused in the way that you do your analysis, you focus on the experience of the victim with sexual assault. So sexual assault is experienced by victims as an issue of power control, and that has become the blanket way to talk about sexual assault in general. So when you say, well, if I'm thinking about the offender, I don't think the offender is perpetrating with power and control motivation. That's actually like, I mean, I've made this up, I guess is my point. Like, I don't, like, this is not something that I've seen thoroughly discussed in academia, and so I'm just assuming it would be controversial because I haven't really heard it before. I just know that within sort of lawyer circles in the military, we seem to understand that there are these cases that are not about, I want to control you. They're about like an amoral lack of respect for the effect that you're having on the other person. And I see that as being very analogous to what we see in some colleges and universities. I see that as being experienced by the victim as a power and control issue, and the trauma manifests itself in that way. But I don't see the offender saying, like, I'm going to take power and control of this situation as being sort of a good lens to look at it through and a good way to empathize with the offender and then to think about how best to prevent those crimes.
Well, thank you very much, Lindsay. We could really spend more time on this, but fortunately, Lindsay's going to be here this evening and tomorrow as well, so if you want to engage her again. And I have to tell you, I wrote a piece, 10 top reasons Senator Gilbrans' bill is a bad idea. It's going to hurt sexual assault victims. I gave it to Lindsay, and let me just say, I don't want to use the word ripped apart or got my mind right, but it was vastly improved. And really, seriously, when you see a young officer like this, as articulate as she is, as focused as she is, as analytical as she is, you got to feel good about today's armed forces, that we still are recruiting. And those of us who served in an earlier generation, we're glad we don't have to compete against the young officers today, because it wouldn't be pretty, and we would be probably doing something else with our lives at this point. Lindsay, thank you so much. And we're going to take a very short break in place, just a few minutes, and then we're going to hear from the ABA president, and then we're going to get ready to go to the dinner tonight. Okay, we're in the 1-minute warning order here. Ladies and gentlemen, we really have a very special treat here. I was talking to my former boss, Jack Rives, who's now the executive director of the ABA, and I was asking, I said, I need somebody really big to close out the day. Not that Lindsay isn't really big, but I'll pay for that. Yeah, we'll see power and control happen there. But, and he said, well, how about the president of the ABA? I said, well, I will never get him. But lo and behold, lightning does strike, and Jim Silkenet was very kind to work it into his phenomenally busy schedule. I really don't know how you do it as president of the ABA and be a partner in a law firm like Sullivan and Worcester. Did I get it pronunciated? And he has as you can see in the bio, he has a long history in the ABA, holding many different positions and so forth. And really, interestingly enough, he was editor of the Law Review at Chicago, which not quite like being the editor of the Law Review at Duke or something like that. I went to Villanova, so, you know. But he's also has an international law background. And in fact, I gather that that's a lot of your practice, Jim, is in international law. So it is really a very special treat to have him come down here and spend some time with us and give us a little bit of perspective from the ABA. Jim, thank you so much.
Charlie, thank you very much. In planning for this conference, Charlie called and he promised me that I would be the youngest speaker at the history of the conference. And it's really disappointing to miss by just a few weeks here. Nonetheless, Charlie, really want to tell you how much the ABA appreciates your service to the Standing Committee on Law and National Security, and also want to acknowledge Judge Sullivan for his long support for these issues, hard work on these issues, real accomplishments in shaping American law in this area. Much of my time during the past 6 months as ABA president has been spent on trying to find funding for federal courts, the government shutdown, sequestration. But as Charlie mentioned, my background is in international legal practice. And because of that, I have long wanted to attend and participate in this conference. After a while, though, it became very clear that the only shot I was ever going to get is if I was ABA president. So I went and did that so I could actually come for this. The ABA has long prided itself on bringing together lawyers and subject matter experts to confer on this critical issue affecting our profession and our nation. We have a very strong committee. In fact, our Standing Committee on Law and National Security is the oldest standing committee in the ABA. It's easy to see that national security law is widely dispersed throughout the government on both federal and state level, as well as in bar associations, law firms. Many large law firms now have practice groups in the national security area, really a growing field. And almost every law school in the country now teaches national security law with topics like counterterrorism law, intelligence law. Many have national security law centers, although not as good as this one, often modeled on the program here. 13 years after the terrorist attacks of 9/11, the U.S. continues to be defined by its resolve and its core values. No matter what area of the law you choose, as lawyers, we must never lose sight of the critical importance of remaining faithful to the rule of law and respect for human freedom and dignity. I practice in New York. My old office was downtown just south of the Trade Center, and the second plane came by my window, not as far as that back wall there, just before it went into the South Tower. So I'm sensitive to these issues and sensitive to the complexities of them. National security is a topic that has been a priority since 9/11, but intelligence gathering has played an important role throughout our nation's history. As President Obama noted in a speech last month, our country's original national security team was a group of Boston patriots that included Paul Revere. They patrolled the streets, gathered information, reporting what the British were up to. They famously hung lanterns from Boston's Old North Church to send warnings across the river to patriots across the Charles River about the movement of the British Army. We have now obviously come a long way from one if by land and two if by sea. Instead of landers and riders on horseback, our surveillance abilities are more sophisticated, obviously, than ever before. And there are certainly more laws regulating surveillance than there were in Paul Revere's day. Our national security strategies are intended to keep our country safe, but these practices must be kept in check with sound laws to protect the very liberties that national security is intended to preserve. We must balance a robust and effective national security policy with a full and faithful respect for the rule of law. Just one example is the attorney-client privilege. We all see this as a bedrock legal principle in a free society. It enables individual and organizational clients to communicate with their lawyers in confidence, which is essential to preserving a client's fundamental right to effective counsel. You really can't have one without the other. The ABA recently sent a letter to the National Security Agency expressing concerns over recent allegations. Many of you saw this in the Times last week. Allegations of possible foreign government surveillance of American lawyer confidential communications with their overseas clients and the subsequent sharing of privileged information with the NSA. We requested clarification on the agency's policies and practices designed to protect the attorney-client privileged information that it intercepts or receives, and whether those directives were followed in connection with the alleged incident involving the Mayer Brown firm that many of you know of. We further urged the NSA not to actively seek confidential communications between U.S. law firms and their clients. That seems obvious. I met last week, actually earlier this week, in New York with the General Counsel of the NSA at a Council on Foreign Relations meeting and received, I think, from him some honest thanks for how we're addressing this issue, how we're trying to handle this issue. And I was sitting here listening to these programs. I've gotten an email that the head of the NSA is sending today a letter to the ABA discussing this in real depth and real detail. If confidential information is obtained by the NSA inadvertently or from foreign intelligence service, we believe the NSA should respect attorney-client privilege and take all appropriate steps to ensure that any such information is not further disseminated to other agencies or third parties. If the information is, as it might be in this case, about trade policy negotiations and the NSA passes those on to the U.S. trade representative, gee, that makes things a little funny, when you're representing a foreign government in trade negotiations with the U.S. The growing threat of intrusions into the computer system of lawyers and law firms risks undermining unfettered attorney-client communication and, obviously, compromising client confidences. The ABA recently revised our model ethics rules to require lawyers to make every reasonable effort to protect attorney-client communications when using digital technology. As we are all now aware, the same digital revolution that has been a boon for the world economy is also a target and method of attack for hackers, organized crime, terrorists, and nations that hope to steal personal, corporate, or government information and disrupt commerce and military operations. Our world, whether it's banking or medical histories or defense research or confidential client records, is really vulnerable in ways that I think we're only now starting to learn about, and I hope we don't get used to it. Information technology has made private data more accessible, and its integration into critical infrastructure like utilities and airports has opened the door to every malevolent actor with an internet connection. I'm proud of the way the ABA is coming together to confront cybersecurity risks, and I'm proud of our association-wide cybersecurity legal task force under the direction of co-chairs Judy Miller and Harvey Rishikoff. We brought this together from each of the different sections and divisions of the ABA. This is something that all parts of the ABA want to participate in, think they have some knowledge about, and want to contribute to. The Cybersecurity Task Force has released a new book the ABA Cybersecurity Handbook, a resource for attorneys, law firms, and business professionals, and that's available obviously through the ABA bookstore. The book provides practical cyber threat information, guidance, strategies for lawyers and law firms of all sizes, and considers the interrelationship between lawyer and client, establishing what legal responsibilities and professional obligations are owed to the client in the event of a cyber attack. It also provides strategies to help law firms defend against a cyber threat, and also offers information on how best to respond if the wall is breached. To offer broad guidelines or guidance for policyholders considering cyber-related legislation, the ABA recently adopted cybersecurity principles that lay a foundation for offering input about the fundamentals our association knows are important, including public-private frameworks, interagency and public-private information sharing, and civil liberties protections. All of those are involved in these issues. The ABA will continue to monitor and propose cyber legislation and represent the interest of lawyers on this issue on Capitol Hill. Whenever I speak to law students and young lawyers around the country, I try to impress upon them the importance of public service. I urge every young lawyer to make a lifelong commitment to service, to become an essential leader and member of your community through pro bono work. This message is especially important for all of us in this audience who have specific knowledge of an area of the law that not only affects our national security, but our personal lives as well. The FBI lists identity theft as the fastest growing crime in the U.S. That surprised me, but I guess it shouldn't have. In fact, recent news reports say that the IRS is really overwhelmed by identity fraud. In just the first 6 months of this year, 1.6 million taxpayers were affected by identity theft. This is compared with 271,000 for all of 2010, so the growth has been exponential. The cumulative thefts have resulted in billions of dollars in potentially fraudulent refunds, just dealing with tax issues. Phishing scams flood our email mailboxes, and malware infects our computers. Information we thought secure isn't. Social Security and bank account numbers are routinely stolen from our holiday shopping websites and from stores. Most of you are, I'm sure, aware of the massive data breach that affected up to 100 million Target store shoppers over the holidays just a couple of months ago. And it's not just retailers. Last week, computer hackers stole the personal identity records of more than 300,000 students, faculty, and staff at the University of Maryland. So they're reaching out really everywhere. This is not someone else's problem. I think all of us are vulnerable. My involvement in the organized bar has continually reminded me that as a lawyer, I have a special responsibility to protect those who most need protection and to insist on a fair and impartial justice system that's responsive to all of the members of our society, not just to those with power or money or privilege. And so I urge all of you in this room to make a profound impact on your careers and your communities by volunteering your time and your talents to these efforts. You may not feel that you have the time, but please make the time. Your pro bono experiences may be some of the most rewarding work that you will ever do. And importantly, you will be addressing a very serious need in all of our communities. In a country founded on the promise of justice for all, many Americans without lawyers go without justice. I know a number of you have served or are currently serving our country not only as lawyers, but also as members of our armed forces. We are so thankful for your service in both capacities. And I would like to use this opportunity to tell you a little about the ABA's enhanced legal assistance for military personnel. That strikes me as being very appropriate for this particular audience. The ABA's military pro bono project is one of a kind venture that improves access to pro bono civil legal assistance for active duty military personnel while expanding opportunities for firms and attorneys to provide those pro bono services. Many of our service members who have left their families and jobs for years at a time to serve their country return home troubled by legal needs. Our troops serve our country bravely and deserve our support, and our ABA Military Pro Bono Project connects junior enlisted military personnel serving on active duty and their families, moves them to civilian attorneys who will provide free representation on civil legal issues beyond the scope of services provided by military legal assistance offices, such as on consumer law issues, landlord-tenant cases, child custody matters. Military attorneys can offer guidance and analyze these cases for merit and legitimacy, but sometimes they are limited in what they can do due to practice rules and military regulation that bar certain kinds of in-person representation. And I'm hoping we can help in this area. I know that we are. Cases have been referred to us from all over the world, from Afghanistan, Asia, Europe, Iraq, among other locations. Intake forms are available on the internet, so a case can be referred by a military attorney to the ABA from any place with web access. Some state bar associations offer similar programs, but these seldom go beyond state lines and are not coordinated with the Department of Defense. The ABA project is the first one, really the first one, where the military's legal assistance services have reached out to work with the private bar. Even with all the good work that is going on, the reality is that the ABA needs more pro bono participation from all of our members from all around the country. Many cases are grouped around military communities in states like California, Florida, Texas, Virginia, and here in North Carolina. But the legal matters stretch from coast to coast. Whether you give your time and talents to our military pro bono project or in some other way, I urge you to volunteer. The need is great, and while you will never earn a cent from working on pro bono, it is some of the most rewarding work that you will ever do. Now, I've learned a lot here listening to programs today, and the one thing that I may steal and use, particularly on ABA Board of Governors meetings in the future, is due process is the process that we do, and I plan to run with that. Thank you very much.
Mr. Silkenet has very kindly agreed to entertain a few questions, and if I could dive in with the first one. Not too long ago, I met with some of our grads in New York City who are in some of the big New York firms, and they're very, very good national security law students, and they wanted to pursue that. They're interested in pro bono, but they're burdened by these huge debts, and they feel that the big firms have expectations of them that really don't carve out space for a very junior associate. I'm summarizing in my own words. Do you have some nuts and bolts advice for law students who may be taking these jobs in the big firms, how they can reconcile this interest in, saying, being active with Human Rights Watch or some pro bono or any one of many opportunities that they have to satisfy the scratch the itch of wanting to do something in the national security arena and pro bono and government service with this expectations of the large firms?
In prior years, when I was asked this question, I would usually quip something along the lines of having a life is vastly overrated for a young associate. I've learned not to do that because it's wrong. What has contributed most to my career and for most of the folks that I see in large firms in New York or around the country who've developed successful careers, if you have only focused on the billable hour, you've gotten left behind. It's the outreach to involve yourself in other things as a leader in your community, to work on national security issues, to work on health law issues. Pick something where you can show that you're different than your colleagues. You're going to have to work hard, that's clear. But if you focus only on what the firm wants you to do, my sense is you're going to get left behind. So I still argue very vociferously around the country that law is the most exciting career one can follow, but one needs to look at it more broadly than just the billable hour.
Thank you. Let's open it up for some other questions or comments. Well, it seems like people want to
drink is what I would say.
Wasn't going to quite put it that way, but you're absolutely 100% right. Jim, thank you so much. And we're going to see you at the dinner tonight.
Absolutely.
And let me say this. The ABA has been, especially, I really think in the last 5, 6, 7 years, has really been much more, they've always been involved. There's always been the committees, but they seem to be much more sophisticated in the approach. And there are lots of very good initiatives coming. The cybersecurity one is just an example that relate very directly to national security type issues. And I'll also say I have the book, the handbook on cybersecurity. And what I've noticed about the ABA books, no offense to anybody, but years ago they were in the areas that I was interested in, shall we say, less than helpful. In recent years, they've come out with some very good titles, and the handbook on cybersecurity is one. If you're in a law firm especially, you really need to get this because, as my students know, I think I'm a genius on everything, but I really, there's lots of stuff in there that you would want to know if you were in a law firm about cybersecurity. Okay, a couple of things. Tomorrow's schedule, we start at 8:30 with Phil Carter. There will be a continental breakfast tomorrow before that. And you can park for free in the law school lot. You don't have to park in the Science Drive lot. I would encourage you to get there early, and just so you know where you are, that's where you are now. That's where we are this minute, and you can see where you come from the Science Drive lot. Well, where you will want to go is down Tower View Road and then turn into the lot behind the law school, and then come in the building entrance back there. And we'll have some of our very bright law students down there, volunteers, to show you exactly how to get back to this room. It's just this building can actually be a little confusing because you're on the 3rd floor now, even though you walked in from ground level because of the way the building is built. If you signed up for the dinner, it's tonight. Believe it or not, last year we had said, well, nobody told me what day it was on. You know, I thought it was Saturday. Okay, well, it's tonight. And it's in the Ambassador Duke at the beautiful Washington Duke Inn. And the reception is going to be right outside of the Ambassador. It's going to start at 6:15. And beer, wine, and soft drinks and water are complimentary, unlike last year. And our dinner will start sharply at 7 p.m. How do you get there? Here's where you see where the law school is. You just go straight down Science Drive to the Washington Duke Inn. You can't. It's just a few blocks. There's parking there, and so forth. Please wear your name tag. There's some secret code on your name tag that says if you actually signed up for the dinner, and it's something Stephanie won't let me have that kind of information because she's security reasons. And of course, check in when you get there. And one important thing to note about the dinner tonight, it's off the record. And so there's no recording, no tweeting, no blogging of remarks. We're going to be on Chatham House rules. You know what Chatham House rule is? Well, let's take a look at it then. Just like my classes, you know. So you can use the information, you just can't attribute it to the speaker. Okay, a couple of takeaways. Reception, 6:15, dinner, breakfast at 8 a.m. tomorrow here. Keynote speaker starts at 8:30 sharp. See you tonight, hopefully, and if not tonight, tomorrow morning. Thank you so much.